The next case is Hinckley Township versus Calvin. Each party will have 15 minutes to present their argument. The appellant may reserve up to 5 minutes for rebuttal. Counsel, how long would you like to reserve?
5 minutes.
All right, very good. I'll be keeping track of times indicated. I'll also let you know there's about a minute left in your initial time so that you can reserve your time for rebuttal.
Thank you, Your Honor.
The arguments are being recorded, so when you present your argument, please introduce yourself. Try to stay at the podium because it's being videotaped, and if you get off of there, we lose you on the videotape, and that will also cause it to lose your voice, so please speak up and do that if you would. You should not use the name of children, minors, or victims during the argument, although I don't know if this particularly applies in this matter at all. We've read your briefs and are ready to proceed whenever you are.
Okay, thank you. Good morning, Judges Carr, Stevenson, and Sutton. This case, I'm Attorney Al Schrader. I represent Hinckley Township in this annexation matter as appellant. This case, I think, turns on the KNG case decided in early 2023. Here's what happened. There's two assignments of error we're going to present, just as we did in Hinckley. I'm going to spend most of my time on 06 because I think that's the one you're going to wind up deciding this case based on. I'd love to get to that second assignment of error at some point. This may not be the case where we do it. Statutes are to be interpreted, applied, not interpreted, if they're straightforward and they're not ambiguous. 709.033A6 requires essentially that when an annexation occurs, if a road is segmented or divided in a manner so as to cause a maintenance problem, that the city must, as a condition of annexation, agree to provide the maintenance service. What happened here is West 130th Street, as it borders Hinckley Township and the city of Brunswick, will, as a result of this annexation, be segmented by about 135 feet. So that meets that qualification. The second is, does it cause a maintenance issue? We say it does. The more important thing is, this is entirely one sentence, and there's some importance to the requirement that when those things occur, the city agree to maintain the road itself and do it as a condition of annexation.
Counsel, I was a little confused, so I want to make sure when I was reading the briefs, does the township have any responsibility for maintaining that road now?
It does not.
Okay, so can't you assume by the factors in the statute that if there's an issue with maintaining the road or a maintenance issue, that would assume that the entity that the property is being annexed from, in other words, the township, had a responsibility to begin with regard to the road?
Oh, absolutely not, and that's
Okay.
because of the way the statute's written. At the tail end, it refers to another section of the Ohio Revised Code that defines roads, and when you turn to that one, it includes county roads that townships are never responsible for, state roads that townships are never responsible for, and even U.S. highways such as 224 the townships are never responsible for. So clearly the state was trying to get at the issue of road maintenance and who's responsible for it. The point here is that as in KNG, there was a road segmentation. I happen to be, now their argument is entirely based on another earlier decision of the Ninth District Court of Appeals, Wadsworth Township v. Wadsworth. I happen to be the attorney that represented Wadsworth Township in that matter. And I was just coming off 28 years as a Springfield Township trustee. In that position, I knew that dividing a road always creates a road maintenance problem, and wrongfully assumed everybody else thought that. So I submitted no evidence whatsoever at the commissioner's hearing on the factual parts of that issue, nor did I make much argument on it. It seemed to me to be a common sense thing. I certainly got an education as a result of that case. So in the record, we talk about how road maintenance is an issue as it relates to ice control, snow control, even deceased animal removal, the least popular job of a road worker, I know, I spent a summer doing that as a college student for the Summit County Engineers Office. The fact is, there's no question that the city did not agree to maintain the road as a condition of annexation. In fact, it didn't agree to maintain the road at all. What it relies on is the notion that despite what the statute says, they can decide to enter into a road maintenance agreement with some other entity, and that's good enough. Forget that the statute requires the city to maintain it. Forget that it has to be as a condition of annexation. In this case, it was allegedly an agreement between the city and the county of Medina. I don't believe that agreement became part of the record, and here's the practical problem with that notion. Statutes generally have some reason for being written, and the language in them has a reason to exist. Here, the notion of the legislature was, we will protect the citizens of both the township and the city by requiring that as a condition of annexation, the city maintains the road. What's the practical effect? Everybody knows it's the city's responsibility. You don't have to figure out if it's the county, did they agree with the state, did they agree with the U.S. Department of Transportation? It's the city.
So in other words, you're saying that they could delegate or contract with somebody else to assume that responsibility, but they have to take on the responsibility themselves as part of the
absolutely
statute.
I'm sorry, I didn't mean to interrupt. That's absolutely what the statute says, yes, and that is our position. Local governments can provide services in a variety of ways. They can do it themselves, they can contract it out. There's a number of things, they can have mutual aid, there's a number of things they can do. But what this statute says is if you're gonna annex and you're gonna segment a road, you need to agree that the city takes responsibility. How they choose to exercise it afterwards up to them, and they have to do it as a condition of annexation, and that did not occur here.
In this particular case, I would assume on Route 130, we have a segmented area that the city owns, surrounded by or not owned, but it's a part of the city property, surrounded by two parts of Hinckley Township. On either side of 130, the Hinckley Township on both directions, other than what will now be annexed.
It's in the record, I think it was divided along the center line.
Yeah, I think it was, that was I understood from the record, and this annexation would mean it's no longer divided by the center line, it'd all be in the city of Brunswick. But would either side be Hinckley Township?
Not after they annex it along that 135 feet.
No, okay, go ahead.
But prior to the 135 feet, and I think again, after the 135 feet, half of it will be in the township. It'll be the county's responsibility, as 130th Street, I believe, is a county road.
Does the county provide road services on each side of it now through contract to the city? Do we know from the record?
Again, I haven't seen the contract. That was the allegation in the transcript of the record. And here's the problem with those contracts. Like any other contract, they can be amended. In fact, there's discussion of it last being amended in 2009, and it last being entered into in 2022. That doesn't provide much protection for the citizens of the township or the city. The other interesting thing about Hinckley Township is currently, it's one of the few townships that exists in its original configuration. It's never been annexed to anything. This, of course, changes that. So the concern, I believe, by the legislature, and certainly our concern, is more regarding citizens. Citizens need to know who to call to get work done. And this statute, if followed, would make it clear. It's the city. How they choose to perform the work's up to them. But they have to agree to maintain it, and they have to do it as a condition of annexation.
So you would say the city needs to pass an ordinance saying we will maintain this portion of the road?
As a condition of annexation.
Annexation. And then later on, if they enter a contract with the county, that's all well and good.
Right,
Because they've already initially said we will accept this.
correct.
And you would say every annexation is going to cause some boundary problem? Or virtually all of them, unless there is no division of a road?
Right, unless there's no division of the road, yes, they will. And that's why the legislature addressed it
You have about a minute left of your initial time.
Unless you have any questions, I'm gonna sit down and reserve that extra minute for rebuttal if I need it. Oh, well, maybe I should spend a little time on the second assignment of error. The legislature also decided that as to general good, it was no longer just the interest of the property owner that you consider. You also have to consider what happens, the balance of positive and negative effects on the unincorporated area within 1/2 mile. The city has the burden of proof. They submitted essentially no evidence on how it affected the unincorporated area of the township. The township didn't have any obligation to provide evidence in that regard, but the city provided none. No expert witness that looked at the balancing issue, none of that. Again, I suspect you're gonna decide this based on the KNG road issue, but I did wanna at least address that. Thank you.
Thank you.
Good morning, Your Honors. My name's Doug Jerschel. I'm here on behalf of the appellee, the somewhat lengthy name of West 130th Street, Route 303 LLC. As Mr. Schrader indicated, this is a statutory case primarily, and the place to start then is with the statute. Turning to his first assignment of error, which deals with subsection A6 of the statute in question, I'll quote, "No street or highway will be divided or segmented by the boundary line between a township and a municipal corporation as to create a road maintenance problem." This annexation does not create a road maintenance problem, so we are done. The issue is who maintains the road. That's in place already. It's not the township's problem. It's the county on one side, it's the state route on the other side. There is no problem created.
So the,
Counsel,
go,
sorry.
no, go.
Counsel, how is this different than the KNG case?
In the KNG case, there was a clear division of a road that was, I believe, a township road that had to be addressed. There was no maintenance agreement in place in that case. So there would have been a problem in the KNG case because there was no agreement in place. Here there was agreement in place already, and what this court held in the KNG case was the issue turned on the municipality in that case. It said, oh, we're going to enter into a maintenance agreement, but they hadn't done it yet. And so this court said, that's not good enough. If you are getting to the second part of the statute, which says you need a maintenance agreement, which I would submit here, we do not need to get to the second part. But in that case, in the KNG court pointed out that in the Wadsworth case, that Mr. Schrader mentioned, only the first part was analyzed. So if you get to the second part and you do need an agreement, well, you need an agreement. And this court, I think correctly held in the KNG case, a prediction that you're going to enter into an agreement or a promise that you might enter into an agreement isn't good enough. The record was very clear in that case that there was no agreement.
Counsel, then how is that really that different from the appellant's position that the city could tomorrow not have an agreement or could cancel that agreement?
Well, if you look at the statute, that let's assume we get to the second prong of needing an agreement. There is an agreement in place. The statute, A6, doesn't say what the agreement has to say. It doesn't say who has to assume the responsibility. It just says there has to be an agreement. And that the city will assume the maintenance. And as Mr. Schrader said, that can be done any different number of ways. It's very common. Every municipality I've ever dealt with has these agreements with ODOT, with counties, with townships, with cities. Very, very common. They're all over the place. And all the statute says is it has to have something that says what the city is going to do to take care of that. That was already in place in this case. It was not in place in the KNG case.
Well, the statute says it creates a road maintenance problem, Okay, and so you're arguing, I think, that there is no road maintenance problem because of the fact that you have an agreement.
Right.
And I guess my question is, there's no road maintenance problem during this agreement necessarily, but due to the fact that that the city could change its mind, or the other entity could change its mind. But if you have something in place, a resolution, ordinance in place that says, we take responsibility, doesn't matter who they are contracting with, the point is they have to do it.
But the statute doesn't say that agreement can ever change.
Where does the statute even, I mean, it talks about the municipal corporation has created a road maintenance problem.
Right, so I would submit here too, that we're not saying that because of the existence of the agreement is the only reason that this doesn't create a road maintenance problem.
Okay.
It doesn't create a road maintenance problem, period.
Well, and that's what I'm trying to understand. I think 303 seems straightforward to me. That's a state route. No matter what happens, the state's gonna provide services.
Right.
That seems straightforward. We have a county road, West 130.
Right.
I'm trying to understand is right now, without an annexation, prior to this being filed, did the county provide services all up and down 130? Or was it a county for a while, city for a while, county for a while, and each side of the road was different? What was going on?
The whole length of West 130th Street, I don't know, and that's not in the record.
Okay.
For this section, it is a county road, which means that under the other sections of the revised code, the county has an obligation to maintain it. The
So
county
prior to
can
this
enter-
point in time, the county was maintaining both sides of West 130.
The county can enter into an agreement with the city, whereby the city will say, we'll take care of it because we have half. And what they do, what the real world is the city will say, okay, you've got a mile or so here where the road's divided, we'll take that one, and you take this one over here.
And is the record clear as to what they were doing before?
Well, the record is very clear that there was an agreement between the county and the city for the maintenance of this stretch of road.
And-
Undisputed.
And the commissioners found there was no road maintenance problem created by the annexation. Is that fair to what their finding was?
Absolutely, that's correct.
And what was their basis for that? Just what was the commissioner's basis for that finding? The existence of the contract, or what else did they base that on?
As I recall, their resolution doesn't explicitly answer that question. So we would have to,
It's not in the record, it's not, or not in their decision, so we'd be speculating as to what their decision was.
right,
Okay.
but that's not a requirement of the statute.
So they found that there was no road maintenance problem? What did they actually find?
Well, I would have to reread the actual resolution adopted by the commissioners to answer that question definitively. But at least impliedly, they decided there was no problem because they either decided there was no problem or that the agreement was sufficient. They had to have decided one of those two. And either one of those is enough. Because the agreement in being in place is all the second part of A6 requires. It doesn't say you have to enter into a new agreement. It just says you have to have an agreement. That if there's going to be an annexation, the city has to say, yeah, we're gonna take care of it.
Okay,
The
it goes,
testimony was clear that that was the case.
the resolution goes back to the first question I was asking, the other side, the appellant. While it appears there could be a maintenance problem on the small stretch of West 130th Street adjacent to the annexed property, Hinckley Township is not responsible for road maintenance in the area to begin with. The petitioner presented an existing agreement between the city of Brunswick and the county of Medina.
Yeah.
And it says the county is responsible for the maintenance of the full width of 130th in the area where the segmentation would be created, and the county will continue to have the same responsibility after annexation takes place.
So what Mr. Schrader is essentially saying is, well, an existing agreement isn't good enough, you've gotta have a new one, even if it says the same thing.
Well, I understood Attorney Schrader to be saying that it doesn't matter if you have an agreement, pursuant to the statute, the city must say, we will be responsible. If afterwards they want to issue an agreement with the county, that's all well and good, but at least the citizens, his argument, I think, would be at least the citizens know that at the end of the day, the city will be responsible if the county's not.
Well, the testimony from the city representatives was to that effect. They said, we have taken care of this. we have a responsibility, and the way we have taken care of it is with this agreement with the county. There's nothing in the statute that says you have to have a new agreement. There's nothing in the statute that says whatever agreement you have in place can't be changed. Mr. Schrader said, well, what if the agreement changes? It's allowed to be changed. Somebody has to maintain it. The default position on West 130th would be the county, because if they don't have an agreement with somebody else to take care of it, they have to under Ohio Revised Code. With regard to 303, the state has to take care of it, no matter what Hinckley Township and Brunswick City would say to one another. So,
But isn't that,
the first right, there's no problem.
but isn't that the purpose of the statute, to say that whenever something is annexed and there's a road segmentation, that the city, the municipality accepting that territory has to take on the responsibility of maintaining that road? Now, they can do it in any number of ways, but they have to say in their resolution, we are going to maintain that road.
I don't read the statute to say that the resolution of the city saying such and such has to include that language. I read the statute to say there must be responsibility accepted. The testimony at the hearing was that the responsibility was accepted. And again, we don't get to that unless we think there's some problem. What's the problem? It must be creating a problem. I don't know what it is. Real quickly on assignment of error number 2, again, if you look at the statute, it's very clear that the decision of the commissioners as affirmed by the trial court was appropriate under section A5 of the statute. The general good of the territory will be served and the benefits to the area outweigh the detriments. What are the detriments? Within a half-mile radius is this defined territory to be considered. If this property is annexed or not, what difference is it going to make?
1 minute left, counsel, please continue.
What difference will it make to the territory in question? I can't think of any. So there's 0 detriments to the surrounding area, and the benefits don't have to be very much in that situation to outweigh the detriments. If the detriments are 0, a little bit of benefit will outweigh that. Here there's a lot of benefit, and it's cited in the record. The tax abatement, full-time police service, full-time fire service, the building department of the city. You have a more sophisticated operation basically with the city than you do with the township in terms of services. So the benefits to the property are overwhelming, and there's really no serious question as to the benefits. And as to the detriments to the surrounding area, the only thing they could come up with is that a police officer came in and said, well, we might be confused on where the boundary is. Well, there always has to be a boundary. Every city, every township has a boundary.
And your 3 minutes is, or your.
You have to know where it is. We would request that the decision below be affirmed. Thank you. And I'll defer to Mr. Fisher.
Good morning, may it please the court. My name is Kenneth Fisher, attorney for Appalachia, City of Brunswick. The issues in this case are clear. The testimony at the annexation hearing from Paul Barnett, Service Director, City of Brunswick, former Service Director for the City of Akron. Agreement in place with the county as to the 130, West 130 segment of the road. And that segment extends throughout Hinckley Township and is maintained by the county per existing agreement at the time of the annexation. Your honors are correct, the 303 segment is maintained by the state of Ohio at all times. So
the record would show us that all of 130 in the township is maintained by the county.
Yes, that's my understanding, absolutely, absolutely. It's all in the township. So it's just that one small segment that's at issue here. And there is an existing agreement at the time of the annexation that there is no maintenance problem created as a result of the annexation because the agreement's in place. And again, I refer back specifically to Ohio Revised Code Section 709.033A6, which reads disjunctively, no street or highway will be divided, and I will quote, segmented by the boundary line between a township and a municipal corporation as to create a road maintenance problem, and there is none, or if a street or highway will be divided or segmented the municipal corporation has agreed as a condition. There is no road maintenance problem at the time. And so what Mr. Schrader is basically saying is that this small segment, and it's a very small segment of West 130th Street, should now be maintained by the city, even though there's an existing agreement for that entire corridor as it extends throughout Hinckley Township down West 130th Street for the county to maintain it. Brunswick is the largest municipality in Medina County, roughly 36,000 people. We have many agreements with the county for maintaining portions of the city that are within the jurisdiction of the county. We have agreements with the state of Ohio. There's no maintenance problem at the time of the annexation, and that's the key to the statute. There's nothing that says the city, it's disjunctive, clearly, or. There's nothing that says the city has to enter into an agreement for this one small section when there's already an agreement in place and the uncontroverted testimony.
Council, why does the city have these agreements?
Well, because again, there's a difference, obviously, Your Honors, between the municipality and the township, and the portions of township property are maintained by law by the county. That's in existence at the time.
Because council raises a argument that the existence, right, the pre-existence of this agreement suggests there could be a road maintenance problem.
I disagree with that interpretation, Your Honor. The agreement's longstanding and it extends throughout the entire West 130th corridor. It doesn't make any sense for the city of Brunswick to enter into a separate agreement for this one small segment. We've got the state of Ohio maintaining 303, and then extending, and this is on the corner, extending down West 130th. That agreement's in place down the whole corridor. And so what Mr. Schrader's saying is that we should have a separate agreement by ordinance for this one small section when there is no road maintenance problem existing at the time of the annexation, per the uncontroverted testimony of the service director. And that goes to the first assignment of error.
But are they saying there has to be a separate resolution, or just as part of their offering for, and the resolution?
Mr. Schrader's saying that this one small section of West 130th, even though there is no road maintenance problem at the time of the annexation, has to be maintained by the city of Brunswick. That's not the law.
That's not my question.
I'm sorry.
My question was, does the city have to say in a resolution that they will be responsible for the maintaining of this particular road after annexation?
I believe that is not a requirement.
Because that's not a difficult requirement.
Your Honor, I don't disagree. I mean, that's why we're here. I mean, obviously, that's true. And could it have been included? Yes. Was it the intent of the city to provide services as required by the annexation statutes? The city must pass a resolution that services will be provided in the event the annexation is granted. The city passed that resolution that services will be provided in the event the annexation is granted. That's a condition before the commissioners have jurisdiction to hear the petition. Then the question becomes, is the decision supported by substantial, reliable, probative evidence and not unconstitutional, illegal, arbitrary, capricious, or unreasonable? I would suggest that because there is an existing agreement in place and no road maintenance problem created by the annexation, that the conditions have been satisfied and the first assignment of error must fail. That's the.
Thank you, counsel. I think you've answered our question, and you are over time. You may briefly conclude.
I'm done then.
Okay, very
You're
good.
done, you're done.
Thank you.
I brought the decision of the trial court, which is about a page, and doesn't really shed any light on why he made the decision that he did. That's what we're appealing from. My memory of the commissioner's resolution is there was a line in it indicating they weren't so sure that 709-033-A6 even applied, or to these particular circumstances. They didn't elaborate, but if they don't know, I guess I'm here to ask this court to tell them. And the statute clearly says the city has to agree to maintain it, and it has to be a condition of annexation. Appellees seem to think that needs to be in a particular resolution of services. It doesn't. They could put it in any resolution or ordinance they chose to pass, but the statute says it has to be the city agreeing to maintain the road, it has to be as a condition of annexation. Second, why do you suppose these maintenance agreements exist between cities and other entities? They exist because anytime you divide up a road like this, it does create a road maintenance problem. West 130th Street happens to be a county road. When it's a county road, it's the county that's responsible to maintain it. Except when it changes hands and part of that road becomes part of the city. And in that case, the statute says the city has to agree to maintain the road as a condition of annexation. It's not Schrader saying that, that's what the statute says. Unless you have any other questions, that is gonna conclude my presentation.
Thank you.
Okay, thank you very much.
The court will take the matter under advisement and will issue a decision in due course. The clerk of court will mail a copy of that decision to you on the day it's released. It's also going to be available on the Ohio Supreme Court website. With that, I'd like to thank all of you for your presentation today on behalf of the court.
Thank you.
Thank you.